and it's a bit complicated. So what I would say is this. In general, if you can travel abroad and get married, I recommend that you do that. So people always say, well, which one is faster, a fiancé visa or a marriage-based visa? Well, neither one is faster. But if your question is, which one takes the least amount of time? I think you'd have to say a fiancé visa. Fiancé visas take less time. The reason that they take less time is that you don't have to deal with the National Visa Center. So when you apply for a marriage visa for your husband or your wife, you have to go through an application process with the National Visa Center. You have to fill out a bunch of forms. It's going to take at top speed about 6 months to get through that process, 6 months. And if you're going through the fiancé visa, you go directly to the interview. So I would say the process might take about 6 months less if you were going through the fiancé visa process, but then rather than the marriage-based visa process. But, and this is important, if you go through the fiancé visa process, you essentially have to file 2 immigration cases. That's right, I said 2 immigration cases, not 1. Now, why do you have to file 2 immigration cases? Well, the reason you have to file 2 cases is that 1 case will get you the visa to come to the U.S. And then when you get here, you have to get married and go through a separate case. So I have to ask you, would you rather do 1 immigration case or would you rather do 2 immigration cases? Would you rather pay an attorney to do 1 immigration case? Or would you rather pay an attorney to do 2 immigration cases? Obviously, it's better. And then there's the possibility that your spouse could come into the U.S. and you could get married, and they could be waiting for a work permit for a very long time. So for all of these reasons, I usually try to take people who want to do the fiancé visa, and I try to talk them into not doing it. And I try to tell them, hey, wait a minute. If you knew what I knew, you would consider the marriage-based visa. Now, there are lots of reasons why you might not be able to do a marriage-based visa. Maybe you can't travel abroad. Maybe you can't get married abroad. Maybe, who knows? But you should consider the possibility of doing that. Consider doing that. So that's a great question. We do a lot of cases based on marriage or fiancé visas. And some people think that when you get married, you have to wait a long time, or it looks better if you get married and then you wait before you file for a green card. And that's just not the truth. That's one of these myths out there. Most of our clients and most people I've worked with in my career, they get married and they file for the green card right away. Does that look bad? No, it doesn't look bad. That's just what people tend to do. They get married and they file their paperwork. Does it look like they got married for the purposes of getting a green card? I wouldn't say that. Everybody who gets a green card through marriage has to prove that their relationship is legit, is genuine, is for real. And sure, maybe they got married. Maybe one of the reasons they got married was to get a green card. It can't be the only reason. You still have to prove that you have you share your life as spouses tend to do. But I don't think it looks better if you hold off on filing your paperwork. That's a mistake that people make and that you shouldn't make. You should get the green card you deserve and file it and move on. Well, you're not required to show wedding photos at all. You're not required to have a wedding at all. What you are required to do, what you do need to do, is you need to persuade an officer that your marriage relationship is genuine. And there are lots of people who have genuine relationships, genuine marriage relationships that don't have weddings or don't have wedding photos. But if you do get married, and it's probably a good idea to take some pictures of that. And I would say two really good wedding photos, especially if your families are there. But you don't need to pile it on. Hello, me and my husband have been married for 7 years, and I'm a U.S. citizen. He is from Egypt. We went to our interview on April 12th, 2023 in Cairo. Our lawyer sent them all the documents, but the embassy is not satisfied with all our documents we sent. We haven't heard from them in several months. What do you think we should do? Well, it's a very common story. and I'm sorry you're having to wait so long. If you go to your visa interview and you don't have a sufficient number of documents, then what happens is they send you a request to provide additional documents. And it sounds like that's what happened, and you responded, you did provide documents. The problem is you haven't gotten a final decision on your case. And what this means is that they're sitting on your case. They're sitting there and they're making you wait and wait and wait. And there's one thing that you know if you follow my content, and that is, I believe that waiting leads to more waiting. There are very few immigration cases that are resolved just by sitting there and waiting. You have to take action. You have to take action to get anywhere. So it's been April, May, June, July, August, September, October, November, almost December. Life is passing you by, and I think you should consider a mandamus lawsuit. File a lawsuit in federal court, sue the government, and force them to make a decision on your case. That's what I think you should do. You should consider doing at this point. Well, can you expedite the visa? There is an expedite process that the State Department has that you can request, and you can submit that request for expedited processing, and you should do that. You know, you can outline why you want it expedited, because you have a compelling need for rapid processing, given the fact that you're expecting a child. Congratulations as well. And, you know, the worst thing that can happen is they can say no. But it doesn't hurt to ask. You're not going to get it expedited if you don't ask. Put the request in. Why not? Why not? I think it's the DS 5535, not to be pedantic, but I think that's what it's called. How long does administrative processing take? Well, one of the most difficult things about administrative processing is that you don't know how long it's going to take. It's a bottomless pit, and you're just in free fall. You don't know where the bottom is. You don't know how long it's going to take. Is it going to take weeks? Is it going to take months? Is it going to take years? You just don't know. So that's one of the most frustrating things. 7 months is a really long period of time. K-1 visas are exciting. You're ready to go and be with your loved one. You're ready to get married. You're going to have a new life in America and get a green card and a visa. And instead, you're stuck in administrative processing, and you go to Google and you start looking, what's administrative processing? How long is it going to take? And maybe you come across some of my videos and go down that rabbit hole. It's tough. So the question is, what can you do about it? Well, you basically have two options. One is you can wait. Just take your hands and sit on them and keep waiting. And how long are you going to have to wait in this scenario? Well, you could wait 3 months or 6 months or 8 months or a year or 2 years. You could wait and wait and wait, and you could try to wait it out. The problem with waiting is that it doesn't work very well. And what happens is that most people at some point get so frustrated with waiting that there comes a point where they just get so mad they can't take it anymore. And they're like, damn it, I am going to sue them. And that's when we come in. We file lawsuits to challenge processing delays and get delayed cases unstuck. 7 months is when I would start thinking about filing a lawsuit. It depends on your personal situation. What would it mean to you to get your visa approved quickly and move on with your life? How valuable would that be to you and your loved ones? What would it mean if you keep waiting indefinitely? These are the questions that I ask people when they're thinking about getting our help. If your I-751, first of all, what is an I-751? An I-751 is a petition to remove the conditions on residency. What does that mean? Well, you applied for a green card and you got a 2-year conditional green card. At the end of the 2-year period, before your green card expires, you have to file a petition together with your spouse to show that your relationship is ongoing and continuing. And that's what the I-751 is. And if you get approved, you get a 10-year green card. That's what you get. The I-751 has been pending since 2017. I'm worried because it's affecting my I-130, my N-400. So if your I-751 is stuck and it's been pending for, this person's I-751 has been pending for 6 years or more or less. If it's been pending for a very long time, what do you do about that? Well, you don't just sit and wait. That's one thing. My message to you is don't wait for your case, because waiting leads to more waiting. So what do you do if you can't just keep waiting? Well, you got to take action. And the first thing that I like to do for a delayed I-751 is file an application for naturalization. File an N-400 if you're eligible. Why not? So what will happen is when you file your N-400, your application for naturalization with your I-751 pending, what happens is you will get an interview for your naturalization. They'll ask you who the president is, what color is the White House. They'll ask you all the questions. They'll give you the English test. They'll go through the whole process of naturalization. But they will not be able to make and approve your, they will not be able to make a decision on your naturalization application until your case, your I-751 is approved. So by filing for naturalization, you've essentially forced their hand. You forced them to take action on your I-751. And the great thing about it is, if you were to get your I-751 approved, what would be your next move? You'd probably apply for naturalization. So it's something you're going to probably do anyway. So I recommend that you do this to get your case approved. Now, one thing that's cool about the naturalization application, besides the fact that it leads to U.S. citizenship, when you have your naturalization interview, okay? Now watch, this is something people don't know about this. There's little language at the very bottom in fine print because they don't want you to see this. And it says that if your application for naturalization has had an interview, and if the interview was conducted more than 120 days ago, you have the right to trial in federal court. You have the right to trial. So you can go to court, you can file a petition, and what you'll do when you file the petition is you'll force USCIS to make a decision. They don't want to do a trial. They will make a final decision. And it's an amazing thing. So if your I-751 stuck, file an application for naturalization. If your application for naturalization gets stuck, then we can help you with a lawsuit. Those are the few things we can do. Oh, wow. Okay. So look, you can get a green card through marriage. Everybody knows that, right? Marriage to a U.S. citizen or permanent resident. But what happens if your relationship is not going well? What happens if your relationship is abusive, or there's domestic violence? Not just physical violence, but a pattern of behavior that is not healthy, normal, or that falls into the category of abuse. Well, in that case, you can invoke what's called Congress set up what's called the Violence Against Women Act, but it applies to men as well. And basically, it puts the immigrant in a horrible position, because in order to get a green card, you have to stay in a marriage, but the marriage is abusive. So Congress recognized this problem and set up the Violence Against Women Act, or VAWA. And what it says is that you can petition for yourself without your spouse if you meet certain conditions. And that is to show that your partner is a permanent resident or a U.S. citizen, and that the relationship has abuse. Now, the VAWA Act is also used in cases of where there's abuse in other types of relationships, like child abuse or parental abuse, things like that. Those are the main. If you have specific questions about VAWA, put them in there. I think one of the things about VAWA is people are always tripped up on, well, how do you prove abuse? Do I need, a video of my partner abusing me or a police report? And typically we do this through storytelling. We take a detailed affidavit from the client and we explain in their own words what happened. That's how we establish abuse. We also use forensic therapist reports. These are therapists who you pay money to, who help you articulate what's going on. And I love working on VAWA cases. We have a great record of success, and I love helping people who are being taken advantage of, or they're in a vulnerable spot, and we can give them a different life, a better life. And that makes me very happy to do that.